This Guy's Garage. Like and subscribe.
I'm curious, given the very clear concerns you've expressed related to parts 2 and 3 of Bill C63, why you're not more concerned about some of the parts of part 1, particularly those related to the Digital Safety Commission, the Digital Safety Office, the Digital Safety Ombudsperson, which would lay some of the bureaucratic groundwork that makes parts 2 and 3 possible. Are you concerned about those parts of part 1, or would you care to give us some specific concerns you have related to part 1 that we're focused on today?
Yeah, I don't think that parts 1 does require parts 2 and 3. I think we can fully separate these, and I think the government should fully separate these. I think in terms of concerns we have with part 1, yes, it's a huge amount of power we're putting into the hands of this regulator. We believe that it is important that Canada has a regulator here in the same way that we have a privacy regulator, we have a competition regulator. Digital safety is a complex and nuanced enough issue that having a source of government expertise helping make good decisions on it is helpful. But that doesn't mean that you should just hand a blank check to this regulator. You need to put some really careful assessments and required limits on that regulator before this bill leaves committee.
Would you care to elaborate on what some of those limitations would be from your point of view that would need to be considered?
The single greatest in our view is that its decisions need to have mandatory assessments of their impact around freedom of expression and privacy. Both the decisions directly made by the Commission, but also when they approve these safety plans, if they approve safety plans submitted by the platforms need to write down what they think the privacy and free expression impacts are. And the regulator needs to assess and determine that those are proportionate, with the opportunity, frankly, for a case to be taken against them, saying that perhaps the plans were not proportionate, so that they make impactful decisions but within bounds.
Again, Mr. Hatfield, there are other bills on the table for consideration. For example, that would be more focused on updating existing laws and making it easier for the existing criminal justice system that we have to be responsive to victims and to hold platforms more accountable. Why do you, it sounds like, and correct me if I'm wrong, why do you prefer the creation of what I would consider to be new bureaucracy as opposed to the strengthening of the system that we currently have?
I think there's a lot to appreciate in Bill C-412. We do think that bill, if this bill does not pass, is worthy of study. But I think Bill C-63 will accomplish more over a longer period of time for Canadians than 412. I think 412 is a narrow, perhaps a too narrow bill. And when it comes to the harms that both of them treat, I think having a regulator involved is really beneficial. Now, if you look at privacy law, we don't just say, here's your privacy laws on paper, and here's a private right of action, go to it, our privacy is defended. We found it extraordinarily valuable to have a privacy commissioner who can assist Canadians in asserting their privacy rights. And our hope for this Digital Safety Commission is they will function similarly.
Yeah, Mr. Hatfield, what I would put forward to you is that you mentioned sort of the long-term effects of part 1. I would put forward that those long-term effects are the very parts 2 and 3 that you're concerned about, which is why I do think a lot of Canadians who agree with a lot of the objectives that the government has expressed related to part 1 are concerned about the ripple effects of what that will mean down the road, especially when the current government has already stated its intentions with a part 2, a part 3, a part 4. I mean, they've already said there will be sequels. And if you are concerned about the sequels, maybe the original may be worth reconsidering. But I appreciate your contributions. Thank you. With the remainder of my time, do I have
1 minute and a half.
Okay, with the remainder of our time, Ms. Laidlaw, I'd like to come to you and just ask for you to elaborate a bit more on the amendments that you had referenced in your opening statement. Just if you'd like to give us a bit more detail and more context, I'd appreciate it.
Yes, thanks so much for that opportunity. What I think is critical, and this is building off of what Matt was just talking about, was there is always a risk of overcorrection if the focus is purely on harms, and that's why it's important that one of the key harms can be to freedom of expression and to privacy in particular, and so it's important for the companies to be filing digital safety plans that explain how they make decisions bespoke to their services, balancing out the scope of harms, but also thinking through a way of doing it that's most protective to privacy and freedom of expression. The Digital Safety Commission would have a duty to consider that, and what they do is just, it needs to also be on the company. I think that the child protection measures, the best interest of the child is protected under international law. And that could become, I think that is the blueprint here. And so detailing specifically what it is about child protection that we're looking for when we talk about safety by design is incredibly important. And of course, algorithmic accountability. I can discuss this further with you, but I'm conscious of time.
Thank you.
We're requiring of the operators that they act responsibly. In other words, what does that mean to act responsibly? Because obviously they have to be able to identify and mitigate types of harmful content, but I'd like to hear your opinion on that.
Thank you. Having had many discussions with other governments, the duty to act responsibly is generally the same as the duty of care in the UK or the due diligence and risk management obligations in Europe broadly. It's all about this sort of due diligence approach of companies at a systemic level. The duty to act responsibly came out of the Commission on Democratic Expression, and it's really practical. Their recommendation was we shouldn't use the language of duty of care. That's language from tort law. It might be confusing if this goes to court. We want this to be a standalone statutory duty where the duty is just set out in the legislation. And so duty to act responsibly captured that better. When it comes to the harms that are included, I think that is a point for debate. In discussions with colleagues, one that could be added to the list is the crime of identity fraud. That is a major issue, and I think it would be appropriate to include that. I think it's notable what's not on the list. A point that I've had multiple discussions about is the inclusion of mis and disinformation, which generally fall into the category of lawful but awful. That is included in the EU legislation. The decision was not to include it in Canada because of, what I would take it as the problematic risks to freedom of expression, that it's will be biting off more than should be taken on for a regulator. One last point. We have to think in terms of what a regulator can take on practically. We know this will cost money. And so some of this, I think, is a discussion of what should we include practically that is the high risk issues that a regulator can investigate and make a difference of now. And I'll leave it there. Thank you.